right. Hi, everyone. Thank you for joining us today. We're going to wait another minute or so before kicking off, just to make sure we give everybody a little more time to join us this morning. Hello, everyone, and thank you for joining us today. Welcome to the California Farm Labor Contractor Association's H-2A 101 Understanding the Nuts and Bolts webinar. My name is Nigel Bocanegra, and I'm the Executive Director for CFLCA. Before we begin, I'd like to address a few housekeeping items. If you have any questions for our speaker, please submit them through the Q&A box at the bottom of your screen. We will address these questions at the end of the presentation. If you're having any technical difficulties, please send me a message in the chat box so that I may best assist you. And lastly, you will receive a follow-up email later today with a link to access the presenter's slides and the webinar recording. I'd now like to introduce our speaker, Tom Bortnyk. Tom is másLabor's Senior Vice President and General Counsel. He advises clients on regulatory compliance issues, oversees the company's quality assurance program, and represents the company on the executive committee of the National Council of Agricultural Employers. Tom has a BS in International Affairs from Florida State University and a JD from Washington and Lee University School of Law in Virginia. Tom, take it away.
Thanks, Nigel. Appreciate the introduction, and I, really appreciate the opportunity to speak to the California Farm Labor Contractor Association. It's certainly a diverse group as far as the types of commodities that you all work with, and yeah, just really happy to be here. So for those of you who don't know, másLabor is the leading provider of comprehensive services for both the H-2A agricultural program as well as the H-2B non-agricultural program. So we actually represent more employers and a greater diversity of industries than any other H-2A service provider. And, we like to think that we're the best. There's a lot of good agents and attorneys out there who do this kind of work. We happen to just do the most of it. And so we certainly have sort of a bird's eye view on the entire industry. I think we've sort of been described as the canary in the coal mine for any issues that come up, because if there's something going on in the world of H-2A, chances are, we know about it first. So Nigel had approached me about doing a webinar to educate your organization about the H-2A program. I know it doesn't seem like California is big in H-2A. Whenever I talk to California growers or California employers, there seems to be a perception that H-2A is not that prevalent. And that's probably true if you're looking at the totality of the state's agriculture. California is the largest agricultural state. So it sort of stands to reason that the industry itself is so massive that H-2A is only a small component of it. But in the absolute sense, there's actually a lot of H-2A workers in the state of California. It's one of the top 5 states for H-2A program usage. And so there are probably a lot more opportunities than people realize to get involved in the program. If you're not already using it, there may be some hesitancy. There may be some reasons why it may not be viable for you, or may not be viable for you yet. But the direction it seems to be going is that H-2A is the future of American agriculture. It's certainly something that is a necessary mechanism for dealing with labor shortages. And in this economy, we've seen sort of unprecedented demand for the program. And the reason for that is because the typical workforce that you rely on is drying up. It's not available anymore, or it's becoming less available. And so we have to turn to alternatives to figure out who's going to do the work, right? Who's going to harvest the crops? And the H-2A program is one way of doing that. It's not the only way of doing it, but it's a way that creates certainty and stability on something that has become more uncertain as time progresses. So I'm going to give a presentation. It's going to go over a lot of basic program requirements. It's going to deal with some California specific items. It's going to deal with some farm labor contractor items. But hopefully it'll address the core program elements, things that you need to be focused on as you consider the program or as you're just getting into it. And then we can certainly leave a lot of time for questions, and I'm happy to stick around and chat for as long as we need to. Go ahead and get started. Okay. Hopefully everyone can see the screen. Okay, so just some basics. The H-2A program has a lot of rabbit holes. I could spend all day on any one topic, and that's not hyperbole. There's a lot to unpack. It's complicated. There's a lot of moving parts. All the things I'm going to talk about is at a very high level. So it's going to tell you the basics of what you need to know, but just understand that we can go in deep and everything is very fact specific. So just keep that in mind. The other thing I'll mention is that I use the phrase best practices a lot. And this is basically referring to the idea of there's a right way to do it. There's a wrong way to do it. Best practices is basically the idea of if you want to be absolutely conservative, if you want to avoid problems, if you want to do it the right way, do it this way. Now that may be above and beyond what the law requires, and that's for your own protection because it is a heavily regulated program and there's a lot of potential landmines to step on. So just keep in mind that when we say best practices, that's really what we mean. So just as a kind of primer for the program, what is the H-2A program? Well, it's a non-immigrant visa program, not to be confused with immigrant visa programs, which is the intent to remain in the U.S. indefinitely. H-2A is specifically a guest worker program. They are here on a temporary basis. They're here for temporary short-term needs, typically on a seasonal basis, right? So you have a defined season, you bring in workers, you may bring in different groups of workers during that season, but then at the end of the season, they go home and they remain outside the country for a set number of months, and then they come back the following season. So it's not designed to address year-round needs. It's designed to address seasonal needs. Now there is some, there are some proposals on the table to have year-round components to it, possibly of a capped number of visas, but the program as it currently exists is only for seasonal and temporary needs. Now, the other sort of core element to this is that it is an America First program, meaning it emphasizes the recruitment of U.S. workers. So before you even get started in the H-2A program, you need to go through a process of recruiting U.S. workers. So the entire role of the U.S. Department of Labor is really to conduct that labor market test and assess the availability of U.S. workers. So the government's role in this process, the reason it's so heavily regulated, is really to ensure that Americans have the opportunity to apply for the job. If they're qualified, they have the right to have that job and be offered employment. And assuming there are no U.S. workers available, it's making sure that employing foreign workers is not going to adversely affect U.S. workers that are already here. And there's a lot of wage protections and rules that are built into the program to try to address that point. So like I said, it is a temporary visa program, and there's a legal definition of the word temporary, just as there's a legal definition of the word seasonal. I will tell you that if you look up the legal definition of what it means to be temporary, it's pretty vague. It just says needs no longer than 1 year, except in extraordinary circumstances. Now, the reality is that the Department of Labor does not certify anything above 10 months. And that's just the line in the sand that they drew. And they say that unless you can show us really ironclad evidence for why your need is greater than 10 months, but shorter than 1 year, we're not going to approve it. And so I typically refer to things in a 10-month context. Obviously, that's not a concrete rule, but anything above 10 months really has to be ironclad. And so it does provide a helpful framework for just keeping things compliant. Now, when we talk about seasonal, what we really mean is that it's a labor need tied to a certain time of year, typically a growing season, but it doesn't have to be, that requires sort of peak levels of labor. So it does assume that you're not shutting down in the winter necessarily. You're not completely closing up shop. It assumes that there is some level of ongoing activity during all times of year, but it's really about supplementing your permanent workforce with temporary seasonal workers. And so I think that is really a sticking point for a lot of employers, because they say, well, we grow things year round. Well, okay, fair enough. But what do your labor levels look like? Do you have ebbs and flows where you need more workers during certain times of year than other times of year? And in most cases, the answer is yes. For most commodities in the agricultural sector, there is going to be a seasonal ebb and flow. And that's really all you need to show in order to be eligible for the program. There are certain industries that are not going to be able to show that. Probably the classic example is most dairy operations, and a lot of mushroom operations have difficulty with that. But for the most part, if you're involved in the agricultural space, chances are you can show some type of seasonal pattern to your operations. Now, the other component to that is that it does have to be agricultural in nature. And of course, there are several legal definitions of what it means to qualify as agriculture. For farm labor contractors, it really comes down to sort of that secondary definition of agriculture, which is to say that the law says it has to be performed by a farmer or on a farm. As a farm labor contractor, you're not the farmer, so it does have to be performed on the farm incident to that farming operation. And so there is a sort of broad leeway with what qualifies, because really anything you're doing on the farm in service of your customers, if it's incident to that farming operation, it's probably going to qualify. So that could be anything on the sort of primary classic agricultural side, planting, cultivating, harvesting, but it could also be packing house operations. It could also be, preparing goods for shipment. Could be that. Really where the line in the sand is drawn is when you leave the farm. That's where we typically have trouble, is when the farm labor contractor is actually performing work off the farm. There are limited contexts where that can be done, but it does have to be sort of incidental and a very small percentage of the time spent off the farm. Now, as I mentioned, it is really a program designed to facilitate U.S. recruitment. There's a process you have to go through to attempt to hire U.S. workers. In the old days, you had to run newspaper ads. Fortunately, they don't make you do that anymore. It's all posted online. But you do have to interview applicants from all sources. So if you have a walk-in off the street and they show up to your office and they say, hey, I'm interested in the job, you have to interview them. And if they're qualified, you have to offer them employment. You have to have a lawful job-related reason for refusing to hire a U.S. worker. Now, in most cases, the lawful job-related reason is that they don't have the experience necessary to do the job. So if your H-2A application specifies, hey, you need to have 3 months experience to do this job, or 6 months experience to do this job. Assuming that experience requirement is approved by the Department of Labor, any U.S. applicant showing up and saying, hey, I want the job, has to meet that experience requirement. And if they don't, that would be a lawful job-related reason. Other reasons might be drug tests. If you require drug tests, if you require background checks, if you require certain licensing, whether it's a driver's license or a pesticide license or something like that, failure to meet those requirements would be a lawful job-related reason. And that obligation to hire U.S. applicants, it continues for quite some time. For most employers, it's going to continue halfway through the contract. Now, there's an exemption for small employers, typically employers that employ 5 or fewer workers on a regular basis. There is sort of this exemption to that rule. But for most employers, it's going to be halfway through the contract. You have an ongoing obligation to hire U.S. workers. And if you find yourself in a position where you do hire U.S. workers and you can't afford to hire another worker, you do have to lay off the H-2A workers before you can refuse to hire an otherwise qualified U.S. worker. So probably not an issue for most people, simply because you wouldn't be here if you had sort of a steady stream of U.S. applicants lining up for the job. But I make this point because it is a core program requirement. Now, the other component to that is that you have to make sure that you're not treating the foreign workers better than you would treat US workers. And there's a lot of regulatory requirements that are built into the H-2A program to ensure protections for US workers. Probably the number one sort of protection built into the program is this concept of corresponding employment. And it's basically the idea that you have to offer the same terms and conditions of employment that you're giving to H-2A workers. You have to give it to any US workers who are doing the same job. And so they're entitled to all the terms of the contract, including the wage rate, all the protections that go into it. And even if housing, if they're coming from outside your geographic area, as well as travel expenses, if they're coming from outside the area. So everything that you would afford to an H-2A worker, you would have to give to US workers who are performing the same duties. Now, of course, that creates your first best practice, right? Because when you're getting into the H-2A program for the first time, you want to be very careful about what exactly you define as the H-2A job position. Because if you are overly broad, right, you can sweep in a lot of US workers into that definition of corresponding employment, and that could really drive up your wages. So you want to sort of follow the Goldilocks principle, right? You want to make sure that you're defining the parameters of your H-2A application to truly address your needs. You don't want to go too broad. You don't want to make it too generalized and have everybody swept up, but you also don't want to go too narrow that it becomes overly restrictive. And so that's where working with an agent, working with an attorney, working with an expert who's familiar with the nuances of the program, they can help you think through those particular components and really come up with a job description that is suitable to your needs and get you the flexibility that you need. So the other sort of core protection that's afforded is what's known as the adverse effect wage rate. So right in the name, you have that adverse effect term in there. And what it's basically doing is it's a government mandated wage rate that is designed specifically to avoid driving down US wages. So it avoids an adverse effect to workers that are currently in the US performing the same job. Now, in reality, we know that there are a lot of flaws to that particular methodology. It's not an ideal system for setting a wage rate, but that's what it's supposed to be on paper. Now, employers in the H-2A program have an obligation to pay the highest of, and there's a few different wage categories there. One would be that adverse effect wage rate. The other would be a state prevailing wage. And that's most commonly seen on piece rates. That's very common up in Washington State. They'll offer a piece rate for apple harvest, for example. And there may be prevailing wages or piece rates that are higher than that adverse effect wage rate. Collective bargaining wage, if you are subject to a collective bargaining agreement, that wage would predominate if it was the highest of these categories. And then, of course, state and federal minimum wage. So if the state of California raises the minimum wage above the AWR, that's the rate that you would have to pay. Now, currently, the California AWR is $17.51 per hour, which is the highest in the country. That's not unusual for the state of California, but that is the current adverse effect wage rate. Now, there are some proposals to change the methodology. The Trump administration came out with a rule sort of in the last days of the administration to try to freeze the AWR at the 2021 levels and have that continue on until 2023. Ultimately, that rule was enjoined. United Farm Workers sued the Trump administration and got the rule stopped. And then the Biden administration withdrew the rule. Now, the other component to that is it would separate wages based on occupation. And so for most H-2A workers, it would maintain the existing wage structure. But for certain occupations like truck drivers, supervisors, things like that, it would actually increase the wages and rely on OES wage data from the Bureau of Labor Statistics. That rule, even though it was stopped during the Trump administration, is sort of rearing its ugly head now. And the Biden administration is contemplating the exact same change. So we could see some movement on that this year. It's not exactly clear how that will play out, but it's something to keep an eye on. I will say that regardless of whether that rule goes into effect, the current adverse effect wage rate structure is going to be in place for most farm workers. So packing house workers, general field workers, ag equipment operators, sort of the bread and butter of the agricultural sector is still going to be on that existing wage structure. Now, this is probably one that is going to be alarming for most people in attendance here. Housing. You do have an obligation to provide housing free of charge to all non-local workers. And when we say non-local, we mean workers that are coming from outside the area, live outside of normal commuting distance. So that would include all foreign H-2A workers, as well as any non-local US workers who you happen to hire. And so the obligation to provide housing is absolute. It's a fundamental issue. And for most people, that's the biggest obstacle, especially in California where housing is in short supply. So the housing, you have to secure it. It has to be inspected and approved by the state. And you have to have enough occupancy to accommodate the full number of requested H-2A workers. So that can be a tall order. Now, that being said, it certainly is possible, and there are options out there, for employers, even in a state like California where it's in short supply. I will point to the success in Washington State, where they similarly, if you go back 5 years ago and even today, there are also housing shortages. And there's things that the growers out there did to adapt to that requirement. And today it is possible to locate housing. Sort of a best advice would be to get creative with it. Because if you're unable to build your own housing, a lot of employers are looking at old motels, decommissioned hotels that are on old highways. Can that be converted into housing? Are there other structures that could be converted into housing? Are there mobile homes that could be set up? Are there temporary housing structures that could be brought in? There's a lot of creative solutions out there. But as a best practice, if you can solve the housing situation, the rest of the H-2A program should be fairly seamless from then on. It's really just a matter of getting over that initial hurdle, and everything else is mostly smooth sailing. Now in California, there are particular housing rules. If you have 4 or fewer workers, your housing is going to be inspected by the California State Workforce Agency, which is the EDD. If it's 5 or greater workers, you have to have a separate inspection done by the Department of Housing and Community Development. And of course, there's a permit process for that. So highly recommended that if you are in that category of 5 or more workers, get started on that process early. Once you secure your housing, make sure to get the permit for it. And there is a permit fee. It's a fixed fee plus a per worker fee for the state to do that. And that can take some time to get that permit done. After the permit is issued, there's definitely an ongoing duty. Every year you have to get it inspected, you have to get the permit renewed, and all that has to happen in advance of when you actually get the approval from the US Department of Labor. The state will have to certify it to the Department of Labor that your housing is compliant and that it's sufficient to accommodate all the workers that you've requested. I mentioned travel. Certainly that is another H-2A program requirement for all non-local workers. So if they are coming from outside the area, you do have to reimburse their travel expenses. So that covers transportation, not only from their home in Mexico to your place of business, but also going to the consulate in between to go get their H-2A visa. It also includes a daily meal subsistence. And so that is another daily rate that is established by the US Department of Labor, and overnight lodging. So if they have to stay in a hotel, for example, while they're waiting for their visa to be issued, you as the employer are on the hook for that. You can also provide transportation directly. A lot of employers, especially if they're bringing in large groups, they can book a charter bus, they can book flights. And depending on where you are in the state, the transportation arrangements may be pretty favorable depending on where the workers are coming from. So you can minimize cost that way. So you do have to reimburse the full travel costs no later than halfway through the H-2A contract. So there is sort of an initial incentive there, to get the workers to at least work halfway through the contract. They are entitled to reimbursement at that point. If they quit, if they get terminated for cause prior to that time, you're no longer on the hook for it. And certainly that's the case with outbound travel. They are only owed outbound travel if they are laid off involuntarily, you know, if you don't have enough work to go around, or if they finish out the contract. But if they are terminated for cause, if they abandon the job, you do not owe their return travel reimbursements. I will say that there is sort of a little bit of a wrinkle to that, which is that some of that initial inbound travel may have to be reimbursed in the first work week, and that comes out of the Fair Labor Standards Act. I won't go into the nuances there, but there may be some portion of the travel cost that needs to be paid upon their arrival, but it's typically a small portion, if any. Now, I will say as a best practice, just to avoid the complicated accounting, most employers do choose to just pay all the reimbursement fees in the first work week. It typically saves a lot of headache that way. Now, the other sort of big red flag in the H-2A program is charging fees. You are on the hook for all fees associated with this government application process. And certainly if you utilize the services of an agent like másLabor or an attorney or a recruiter, if you're relying on a recruiter in Mexico or elsewhere to do that initial recruiting and worker processing, you have to pay all the costs. It is illegal to charge those fees to workers or to solicit fees from those workers. So you're on the hook, and it is something that the government takes very seriously. We've known of instances where a fee allegation has been reported to the consulate, and the consulate canceled all those visas and sent the workers home. So that can be pretty significant. So it's something to keep an eye on, and all the more reason to only work with reputable professionals. Know who you're dealing with south of the border, know who you're doing business with, and make sure that you're getting good, ethical, reputable service providers, because there's a lot of unscrupulous actors in this business, and do your diligence to make sure that you're working with people you can trust. Now, there's some other obligations to go along with that. You are on the hook for their visa fees. You're not on the hook for passport fees. You know, that's something that they can utilize whether they're employed for you or not. And so the current visa fee is $190 per worker. There is a proposal to increase that to $310 per worker. So that's one additional thing to keep in mind, that may be happening this year. If you are providing housing and your housing has kitchen facilities, the workers are just going to buy their own groceries. So you are obligated to take them into town once a week to buy groceries, but they are on the hook for all those expenses, and they will go ahead and prepare their own meals. If your housing does not have kitchen facilities, you do have an obligation to provide meals to them, 3 meals per day. You're allowed to deduct for at least a portion of that cost. So the current rate is $13.17 per day. That's the maximum you're allowed to deduct for the cost of meals. You can petition the government to charge a higher fee if you can show that the cost of providing meals is greater than that amount. But that is a separate process and a separate approval that you need to get from the U.S. Department of Labor. And in terms of daily transportation, you do have to provide them transportation to and from the work site every day, and certainly between work sites. So if you're servicing multiple growers, if you have different contracts you're operating on, you need to make sure that they have transportation to and from all of those work sites. And then, as I said, weekly trips into town as well. Now, for farm labor contractors, I'm sure everybody is familiar with the federal FLC licensing process. Dealing with San Francisco is a bureaucratic nightmare. Unfortunately, that rears its ugly head in the H-2A program as well, because you need to show that you have the licenses necessary and that you have the authorizations necessary. So the Department of Labor is going to expect that you have a valid license, that you have valid licenses for your employees who need to be licensed, and that you have enough vehicles approved on your license to be able to transport all the workers you intend to hire. And so that is a big problem now with all the backlogs in San Francisco, getting those timely to where we can get them to the Department of Labor during this filing process to get the approvals. There's some other requirements that go along for farm labor contractors, one of which is you have to provide copies of contracts with all your growers. You need to disclose all the growers on the front end. We typically find that that becomes a problem if you are locking down those contracts at the last minute, which is quite common. That can be a challenge because certainly you are unable to add contracts later once it's been certified. So if you find yourself adding a contract sort of mid-season, you may need to file a brand new H-2A application for that. The other thing that you have to do, and this is another H-2A filing requirement, is you need to actually give them an original surety bond to prove that you can meet your financial obligations. And that's based on the number of workers, the bonding amount. So certainly you have to comply with state FLC law, but there's also all these federal requirements that you need to do and show as part of the H-2A filing process. So in terms of the process for getting started, it's a pretty linear sequence of events. You're dealing with the state of California, EDD, and you're dealing with 3 different federal agencies: the U.S. Department of Labor, you're dealing with the Department of Homeland Security, and you're dealing with the U.S. State Department. So the state's job is to evaluate compliance with state law and to conduct the housing inspection and to facilitate that recruitment, right? Because their mission is to find U.S. applicants that are willing to take the job, preferably locally. So the state of California is going to try to find farm workers in the state of California that is interested in your job opportunity. So the very first step in the process is going to be filing what we call a job order with the state of California. And that job order is basically going to be a job advertisement. It's going to outline what the job is, how much it pays, when the job is, where the job is. All those material terms and conditions of employment are going to be spelled out in that job order. And that job order will be made available to anybody in the state of California or elsewhere to go apply for that job. And if there are interested applicants that contact the state of California, the state will refer them to you and say, hey, you need to interview this guy, you need to interview this woman. If they're qualified, you need to offer them employment. So that state filing happens 75 to 60 days before you need the H-2A workers to arrive. You can't file any earlier than 75 days out. And unless it's an emergency, you can't file any later than 60 days out. So if you think about the H-2A program and think about the timing of it, it's best to budget about 3 months at a minimum to be able to do this right. I would highly recommend in California, you start even earlier because there's that housing component as well. So 120 days would probably be more realistic as far as start to finish what it takes. But assuming you get started at the earliest time, that'll be 75 days out when you file with the state. Once you get the approval from the state, you move on to the U.S. Department of Labor, where you file your H-2A application. And that's that labor market test that I talked about earlier, where it's really about assessing the availability of U.S. workers. Once you get through the U.S. Department of Labor process, you will have what's known as a labor certification. And that's really an official determination from the U.S. government that affirms you didn't find any qualified U.S. workers who are interested in the job. You then take that labor certification and you file your H-2A visa petition with the Department of Homeland Security. And so the Department of Homeland Security then evaluates whether you are eligible to use the H-2A program. They'll evaluate whether you have a legitimate business, that you're not trying to defraud anybody, and they'll verify that you are indeed qualified. Once they approve that, they will send the approval notice to the U.S. State Department. And then that's when you can schedule visa appointments for individual workers abroad to go apply for those visas that have been made available. So it's sort of this chain of events that has to occur through different levels of government to get to the end result of actually getting an H-2A visa. So a couple things to think about pre-filing. Are you going to use an attorney? Are you going to use an agent? Are you going to self-file? There's plenty of people who choose to handle the entire H-2A process in-house. You have to be prepared to do that, though. There's a lot to manage. There's a lot of deadlines. There's a lot of nuance, and there's a lot of things that can go wrong. So figure out when you're doing that initial assessment of hey, I'm going to pursue the H-2A program. I'm ready to get started. How am I going to go about doing this? You may say, hey, we have a great HR department. We have great experts. We have a legal team that can handle this. They're going to get up to speed and they're going to handle it. Or you may say, you know what, we're going to bring in outside consultants. So we're going to hire an attorney. We're going to hire an agent. We're going to call up másLabor and see if they can help us with this. But have a game plan. That's the key takeaway. Have a game plan. And if you choose to do it in-house, or choose to utilize sort of a DIY type service, make sure you know what you're getting into, because there's a lot of landmines and things that can go awry. Get your housing in order. Figure out a housing plan. Do you own housing? Are you able to lease housing? Is there housing that some grower in the area has that they're not using fully, that lines up with when your contract is? Are you going to be able to meet those housing standards if you buy an old farmhouse, or if you convert housing into, from another use, whether it's an old motel? Are you able to meet those health and safety standards and get that permit? And can you get the permit in time? Figure that out. Is your business information current? As I said, the U.S. Department of Homeland Security is going to be verifying that you're a legitimate business. Is your paperwork with the state of California in order? Are you up to date on your annual reports? Do you have corporate documentation and records that you can provide if you're questioned on it? Is your FEIN current? Do you have a new FEIN? Those are all things you'll want to sort out on the front end, because it can create complications down the road. And then, of course, working with compliance consultants, working with agents, working with attorneys to figure out the parameters of what you want the H-2A job position to be. Do you just have a need for farm workers? Do you just have a need for ag equipment operators? Is it a hybrid between the two? And what are the implications of that? There's a lot of things to talk through, especially if you have U.S. workers on your payroll. What are they going to be doing? Are they going to be doing the same job? Is it going to be a different job? How much overlap is there? There's a lot of nuance and decisions that need to be made on the front end before you even start the process. And so if you choose to use an agent or choose to use an attorney, the next question would be, what level of service do you need? There are some attorneys out there, there are some agents out there that are basically just there to do the paperwork. Maybe that's all you need. Maybe you just need someone to help you through the government filing process, but you have, job fairs and everything, and you do that all in-house to do your own recruiting, perfectly fine. There may be an interim service where they help with the coordination, but they don't recruit. And then there may be pure recruiters who help with the full process and sort of a one-stop shop. Figure out what services you need. Figure out what you're prepared to handle in-house and what you're not prepared to handle in-house, and figure out what level of services is appropriate for you. I always think it's the best practice. H-2A is a lifestyle change. And I say that, that's a phrase I've borrowed from one of our clients. It really is, though. You have to adapt your business model, and you have to adapt your way of thinking and way of doing things to fit H-2A. Now, that's not to discourage anyone from using H-2A, but just understand that once you go H-2A, very few people go back. And for one thing, it's because they get the certainty they need. And for another thing, they've sort of already adapted their business model and made it work. It's best to think about the H-2A program as more than just paperwork. If you think about it just in terms of paperwork, you sort of miss the forest through the trees. There's a lot of pitfalls. There's a lot of potential problems, and you have to sort of know what you're in for as you approach the program. So always just keep that in mind when you're evaluating how you're going to approach the program and what outside resources you need to bring to the table. So as I said, the first step in the process is definitely the state workforce agency. Filing as early as possible really does maximize your chance of timely worker arrival. We sort of ran the numbers on that, and what we found is that there's a very strong drop-off. If you're filing later than 65 days out from your start date, there's a very high probability that your workers are going to be late. Now, that doesn't mean that they're going to be drastically late. It just means that you're going to be off target. So if you have those contracts and your growers are expecting your guys to show up on a particular day, filing as early as possible is going to really maximize the probability that you're going to be able to meet those contracts, and you're going to be able to show up on the day you told that grower that you'd be showing up. As I said, the state workforce agency is going to evaluate the job order for compliance. They're going to be looking at state law, and California is certainly one of the tougher states to get through. California has a lot of pet peeves that they pick on. There's a lot of nuance to the way they want to see that job order structured. And if they identify an issue or what they think is an issue, they will certainly let you know and give you the opportunity to correct it. And they're going to be looking at things like experience requirements. They're going to be looking at the content to figure out if it's compliant with state law and if it's, consistent with what's normal and accepted for non-H-2A employers. As a best practice, if you can, it's always good to strive for at least 3 months of experience as a baseline job requirement. And what that does is that ensures that you at least have workers that are serious about the job. Maybe they have a little bit of experience and they've been around the block. They're not going to be surprised when they show up and figure out that agriculture is very hard work, right? So 3 months is typically a sort of baseline threshold that the state will accept, that the U.S. Department of Labor will accept, and that can really get you workers that are going to be able to do the job. Now, once the state accepts the job order, it's going to open up your recruitment period. And that's when the clock starts ticking on from that moment until the 50% point of the contract, where you really have to be diligent. And you have to ensure that you're processing all U.S. applicants, regardless of how they contacted you, and giving them a fair shake at the job. And so that's one area where there's a lot of compliance issues. You want to make sure you're doing it right. You want to make sure you're documenting all contact with any applicant who contacts you. Because again, it's all about U.S. recruitment. And if you fail to show that, there could be some serious liability. You also have to contact former U.S. employees. So if you had seasonal workers that you employed in the past, you do have to reach out to them and offer them re-employment under the H-2A contract. So if you had seasonal workers that you laid off or that completed the season, reach out to them, document that you reached out to them. And if they want to come back for the job, you are obligated to offer them re-employment. If they don't, that's fine, but you do have to document. Now, what the U.S. Department of Labor is going to be doing is looking at the approved job order from the state workforce agency. They're going to be looking at all the supporting documents, and they're going to be looking at your H-2A application. And ideally, everything would be consistent and everything would be compliant with both state and federal law. Now, this typically occurs 45 days out from your start date, but certainly you are able to file as soon as the state approves it. So if the state has a quick turnaround, you can certainly do it much earlier than 45 days out. All these filings are done online. Both the state and DOL filings are done through what's known as the Foreign Labor Application Gateway. So it's an online portal where you submit those and you get all notices through that portal. So once DOL accepts it, then it's going to open it up for nationwide recruitment. And so they do post the job on a government website known as seasonaljobs.dol.gov. It's set up specifically to facilitate U.S. workers interested in seasonal employment. I will tell you that in practice, the vast majority of workers that are applying through seasonaljobs.dol.gov are foreign workers looking for H-2A jobs. We get a lot of Mexican workers. We get a lot of Brazilian workers who contact us through that. So that gets posted there, and then it's going to give you a deadline for submitting what they call your recruitment report. And that's that documentation I talked about, where it's documenting all applicants. It's documenting everybody that you reached out to about the job opportunity and the hiring disposition. Did you hire them? Did you not hire them? Why didn't you hire them? All of that's going to be compiled in a report and submitted to the Department of Labor as part of that labor market test. And once you submit that recruitment report, that's when you're going to get your labor certification. So then you move on to the Department of Homeland Security. It's The actual agency that adjudicates it is U.S. Citizenship and Immigration Services, which is subordinate to the Department of Homeland Security. And they evaluate the labor certification that you got from DOL, and they evaluate your business information and other such information like that. All of those are still filed on paper. So you package everything up and you send it on its way to the processing center. It's actually located in lovely Laguna Niguel. Interesting that a very ugly government building is right in the middle of very prime California real estate, but that's the way that it is. And there's a picture of it right there. And so they're going to confirm your basic program eligibility. Now, most H-2A petitions are going to be unnamed, which means you're just filing for a set number of visas. 10 workers, I need 20 workers, I need 100 workers, I need 1,000 workers. You only have to name individual workers if it's an in-country transfer. So that's sort of another option. But if the workers are already in country and you want to extend their H-2A status and move them to a new H-2A contract, you would have to name them individually. Otherwise, it's just going to be an unnamed petition. So you don't need to identify specific workers. And in fact, if you're bringing in out-of-country workers, it's advisable that you don't identify specific workers. You want that flexibility to be able to replace a worker if there's an eligibility concern, right? If they don't have the approved vaccine and can't travel, if they don't, if they had prior illegal presence and aren't eligible for a visa, that gives you the flexibility to replace a worker at the last minute if needed. Now, once you get that petition approval, then you move onward and upward to the U.S. State Department. It's all handled through the Bureau of Consular Affairs, which sort of administers all the U.S. embassies and consulates around the world. Workers can apply for that visa anywhere in the world at a U.S. consulate. Typically, it's in their home country, but it doesn't have to be. Almost, I would say 90%, if not more, of H-2A workers are coming through the U.S. consulate in Monterrey, Mexico. That's sort of the unofficial headquarters of Mission Mexico as far as the H-2A program is concerned. So the vast majority of workers are coming through that particular consulate. In California, it may make sense to cross workers at a more geographically favorable consulate like Tijuana. Also fine, they are able to do that. They just have much less capacity at that consulate. Monterrey is sort of the favorite because it just has the most visa capacity to be able to process large quantities of workers. Now, the exact process varies by country, varies by consulate. So just make sure that if you are handling things on your own, to familiarize yourself with those procedures so that you don't have any delays or screw-ups. And the other best practice here, don't assume that workers can navigate it on their own. You know, even if they've been through the process before, have somebody on the ground that can help them. Have somebody that can just double check their DS-160 visa application and make sure everything is correct. Make sure that they get to the consulate on time. Make sure that they have their passport in order. Just have someone there to help them with that, because it is a complex process. Now, if you need assistance in that regard, there are professionals who do this for a living. You know, they're known as worker facilitators. They are professionals who specialize specifically in not only recruiting workers, but helping them through that process. And they can do any number of services, whether that's vetting experience, whether that's, you know, doing COVID tests, doing vaccine checks, anything that needs to be done in advance of that appointment, they can typically handle. They would also disclose the contract. They would apprise workers of the terms and conditions of employment so that the workers are ready for that consular process. We work with probably 4 or 5 different facilitators in Mexico. We also have facilitators in Guatemala, El Salvador, Costa Rica, South Africa. So depending on what agent or attorney you're using, and depending on what resources they have or what resources you choose to develop, you know, there may be different levels of service and different pricing involved for that. But it is highly recommended that you do choose to use a third party, again, make sure that they know what they're doing, make sure that they have a track record of success, make sure that they're ethical, and make sure that they're compliant with the prohibition on fees. Because if they charge fees to workers and they're skimming money off the top, the government's going to hold you as the employer accountable. You know, they can hold the facilitator accountable, but really you as the employer are going to be liable for that. So always do your diligence, always do your homework, make sure you know who you're dealing with. And that's all I have. Like I said, I'm happy to stick around and answer questions. I know I covered a lot of ground. There's a lot to digest. So happy to talk about any of those topics that I covered and go into greater detail, or even talk about anything else that's on your mind.
Thank you for that presentation, Tom. And as you said, we now have some time to answer some questions. So as a reminder, if you have any questions for Tom, please send them through the Q&A box at the bottom of your screen. Our first question for you, Tom, is, does the H-2A program allow FLCs to provide H-2A workers to clients who operate state legal cannabis farms and cannabis product processing operations?
So it depends what we mean by cannabis, because hemp is legal. And if you have a state hemp license, you can use the H-2A program for that. And so there is a legal definition of what constitutes hemp versus marijuana. And it has to do with the level of THC. What is it? 0.03. I'm going to get that wrong. But if it qualifies as hemp, they can use the H-2A program for that, and everything you do related to that is going to be perfectly legal. Where you're going to run into trouble is if your cannabis product is over the threshold for THC, such that it would be considered marijuana. Because that is federally regulated, and there is a generalized obligation in the H-2A program to adhere to both federal and state law, they do not currently allow marijuana cultivation or work in the H-2A program. So the only way that that would change is if there was a change to federal law in that regard.
Thanks, Tom. Our next question is, if a foreign worker is, 1, currently employed as an H-2A worker, and 2, already in California and is no longer needed by their current employer, can they apply to fill our H-2A positions from within the state of California?
Yes, they can. So that would be the transfer that I talked about. So important thing to keep in mind, you know, if you want to do a transfer in that scenario, both the employer that is currently employing them, they're going to have a labor certification. And the new employer, the employer that wants that worker to transfer to them, is going to also have to be certified. So everybody has to have a labor certification. And when you want to make the transfer happen, you have to file a transfer petition. And so that's going to be basically the same process that you would do for an out-of-country worker. The key difference being that it's going to be a named petition, meaning you're going to have to identify the particular worker. You're going to have to show that that worker is currently in the US. And the way you do that is, you know, provide copies of recent pay stubs, provide copies of their visa, and provide copies of their travel history from US Customs and Border Protection. There's a website you can go to, and if you put in their passport number, it'll show you every entry and exit in their history. You would have to compile all of that and send it as a named petition to the government. Now they can do that and legally transfer, and of course that's going to save on transportation and everything because they're already in California. Probably the biggest obstacle that you're going to run into with that is making sure that they are still eligible for the visa. So there is a time limit of 3 years before they have to leave and go reset the clock. So they can jump from contract to contract for up to 3 years. Once they hit that 3-year stay, they do have to depart the US and remain outside the US for at least 3 consecutive months before they're able to come back and be employed again in H-2A status. So it is possible, but it certainly depends on that individual worker's circumstances and how close to that 3-year limit he or she is, because if your contract period would put them over that 3-year limit, the Department of Homeland Security is not going to approve that worker for an extension of that H-2A status.
Thanks, Tom. And folks, as a reminder, if you have a question for Tom, please send it through the Q&A function at the bottom of your screen. Tom, you've provided a great overview of the program. Where do you see first-time users of the H-2A program running into issues most often? Where are those areas that they should, potentially spend a little bit more time making sure that they've done their due diligence on?
I would say the compliance side of things, like I said, H2A is a lifestyle choice. It's once you go H2A, you need to be all in, right? It's not something you can do casually. It's not something that you can do as, I'm just going to dip my toes in and see how it goes. You really need to be committed to understanding the implications of the program, right? Because it is a heavily regulated program. There are a lot of landmines. There's a lot of rules you have to follow. Some of the rules are going to defy common sense, right? Things that you would say, why on earth would that be a rule? Well, guess what? You're not in rational land anymore. You're in H-2A, the U.S. Department of Labor land, and the rules don't apply, and it's just a nightmare. So understanding what you're getting into. Now, that's not to say that these rules are so cumbersome that they're going to destroy your business. They won't. You're going to be successful. You're going to be, wishing you had gotten into H-2A earlier, but you have to at least comprehend, the baseline set of rules to stay out of trouble. And if you can stay out of trouble, you're going to be wildly successful in the program. And like I said, you're going to wish that you did it 10 years earlier. It's when you run into problems and you're not taking the obligation seriously that you run into lawsuits, that you run into audits, that you run into all these things that can really make the program difficult to use. So definitely put all your investment into compliance. Make sure you're dealing with agents and attorneys who know what they're doing, who are experts with a proven track record. Make sure that they're giving you compliance resources, right? It's not just about the paperwork. What resources are they giving you? Are they giving you, compliance information? Are they giving you sample forms? Are they giving you guidance? Are they on call if you have questions? Know who you're dealing with. Make sure that they're giving you right information, and make sure that they're active and staying engaged with you to help you understand the program requirements.
Thanks, Tom. Our next question is, can I apply for an Iranian worker to work in a saffron field?
Interesting. So there is an approved list of countries that it comes out annually. It's a collaboration from the U.S. State Department and the Secretary of Homeland Security, and they evaluate what countries are eligible to use the H-2 programs. And they come out with a list, and some years they add countries to it, and some years they take countries off the list. Iran is not currently on the approved country list, and so that would be difficult. What I will say generally, though, is if there is a country that is not on the approved list, it doesn't automatically preclude them from getting an H-2A visa. What you need to show is that it's in the national interest of the United States to admit that particular worker on an H-2 visa. The classic example I can give would be, I don't know how many people here are familiar with beekeepers, but beekeeping is a big deal in Nicaragua. You can get a college degree in beekeeping and apiculture from Nicaragua. And so the workers there are very, very skilled at beekeeping. There was one year where they took Nicaragua off the approved country list. And a lot of beekeepers were upset because their key guys are the experts. They are the best beekeeping workers you can possibly get. Suddenly they weren't eligible for H-2A visas. They had to show, and they had to petition the government and say, it is in the best interest of the United States because these workers possess skills and knowledge that is relevant to this job. And I can't easily replace them with a worker from another approved country. So I would never say never. It really depends on the individualized circumstances, but the more of a case you can make that it's in the business interest, that what they are doing is a unique skill, that it's not easily substituted, the more of a chance you would have for approval of a non-approved country.
All right, I think we have time for one last question here. And it reads, do the normal set of state workers' compensation rules apply to H-2A workers?
Yes. So normal workers' comp rules, you are obligated to provide workers' comp coverage consistent with state law. So if it complies with California standards, it's going to comply with H-2A standards.
Thank you, Tom. All right, folks, that is all the time that we have for today. So, Tom, thank you so much for joining us, for answering our questions, and for the great presentation. It was a pleasure to have you with us.
Yep.
Thank you to everybody who joined us today, and we hope that you learned a lot from today's presentation.
Thanks a lot, Nigel, and pleasure being here. Again, I'm sure Nigel can share my information, but if anybody has any questions, just feel free to reach out. Happy to chat.
And again, everyone will receive a follow-up email today that will include a link to access the speaker slides, and those do include Tom's contact information on the last slide. So you can follow up with him, as he said, for any last questions you may have. Again, thank you all for joining us today. Hope to see you again next time. Take care.
Thanks.